afternoon, or morning for some of us. I'm Drusilla Stender-Ramey, a leader of the ABA section on civil rights and social justice. On behalf of its Rights of Women Committee, I'm thrilled to be moderating our panel today entitled A Woman of Power, Justice Ruth Bader Ginsburg, Her Legacy in Context. And I want to give special thanks to our magnificent staff and to the committee members who were most responsible for this program, Lakshmi Gopal and Kristen Giles. I should say that Justice Ginsburg herself was a member of this section and was the first woman to receive the storied Thurgood Marshall Award. This panel is one of a series of rapid response seminars from the section, and many more will follow. And I urge you to visit ababar.org/CRSJ for program updates, and especially join our Rights of Women Committee, which meets every second Monday of the month at 4 o'clock Eastern Time. During today's program, if you want to pose questions, and there are 1,100 of you out there, so we're not going to answer all of them, but if you would like to pose a question, please indicate a specific panelist that you'd like to have answer it, and use the Q&A function, not the chat function. If you don't see the controls, ensure that your screen is not idle, whatever that may mean. We will address as many of your questions as we can at the end of the presentations. We will also be recording this program, and anyone who is signed up for this program can share the tape, and we'd love to have you share it with your networks. And with that, we're honored to bring to you today a program that is featuring three most distinguished and compelling speakers: Justice Ginsburg biographer Wendy Webster Williams, former Justice Ginsburg law clerk Margot Schwanger, and Ria Tobacco Marr, director of the ACLU Women's Rights Project, which was inaugurated around 50 years ago by, yes, Ruth Bader Ginsburg. Following presentations and feedback of the panels, then we will open it up to your questions. So let me start then with Professor Wendy Williams. And I obviously have had to abbreviate these introductions because otherwise that would take up the entire hour and a half. So apologizing for advance, and I'm leaving out an extraordinary amount of material about each of our panelists. Okay. A 1970 graduate of Berkeley Law at the height of the Vietnam War, Georgetown Professor Emerita Wendy Webster Williams is a nationally acclaimed teacher, scholar, and expert on women's constitutional status, and biographer of Justice Ginsburg, having already, with Professor Mary Harnett, worked with the justice to put together the book In My Own Words, which many of you may already have, a collection of the justice's speeches and writings. And now, again with Professor Harnett, co-authoring what will surely be the definitive biography of Ruth Bader Ginsburg. After clerking at the California Supreme Court, and there is a story there that she might want to get into, Professor Williams co-founded San Francisco's Equal Rights Advocates, which I had the honor of chairing for a long time, from whence she argued Geduldig versus Aiello, the very first pregnancy discrimination case to come before the Supreme Court. And I must add that it gives you a shocking window into the mindset that Justice Ginsburg first faced when she was beginning to deal with the issue of women in constitutional law. It is a truly bizarre opinion. Shortly thereafter, Wendy bolted cross-country to join the Georgetown Law faculty, much to our consternation, of course, in California. Among her many signal achievements, Wendy, with others, co-drafted and testified before Congress on the Pregnancy Discrimination Act of 1978 that dealt with terrible decisions like Geduldig.
Do you mind turning it down a little?
Sure.
Thank you.
And the Family and Medical Leave Act of 1993. She has served as the president of the Society of American Law Teachers, which is kind of the respected left of the legal academic world, chaired the advisory board of Ms. Marr's ACLU Women's Rights Project, and here you can start to see the interlocking directorate, and was co-founder of and still advises the Georgetown Women's Law and Public Policy Fellowship Program. Professor Williams is the author, our co-author of numerous articles, a book, and a case book on gender and the law. Okay, to get to my question for you, Wendy. Lily Tomlin once said, I always wanted to be somebody, but now I realize I should have been more specific. It seems, however, that Ruth Bader Ginsburg always was very darn specific from even her earliest days as a civil rights lawyer. So Wendy, here's my question to you. What were the changing times and tides for women equality in law and in life in the late 60s and early 1970s? And how did they shape and then were in turn shaped by Ruth Bader Ginsburg's early approach and victories?
That's going to take more than 10 minutes, but I'll do my best. So, how exactly did law professor Ruth Bader Ginsburg, who spent the 1960s at Rutgers Law School teaching civil procedure, conflicts of law, and similarly exciting courses, suddenly in 1969 morph into the leading lawyer for women's rights and gender equality in the United States? I'm going to talk about the times and her circumstances, and we'll see how far we can get here. First of all, I want to say that after teaching for 7 years at Rutgers, in the fall of 1969, Ruth Ginsburg got tenure. Barely, but she got it. And then for the first time, she had job security. She was now a free woman. And immediately after getting tenure, she turned her attention to addressing women's second-class citizenship in the United States law and world. She taught about it, she wrote about it, she spoke about it, she authored a casebook about it. She worked to change the institutions of which she was a part to reflect a better situation for women. And she, on the side and in the middle of the night, wrote briefs and prepared for Supreme Court arguments. Now, what inspired her to make this apparently abrupt and complete pivot away from her previous interests? She certainly, her own life experience, looking back at it, included often painful explorations on her part of the boundaries of women's place in a man's world. And here are just a few examples. Some of you may have heard of them. She went to Cornell undergraduate on a scholarship, acutely aware that her mother, who had died just days before she graduated from high school, had had to forego a college education. Why? Because she was assigned to work to pay for her brother's years at Cornell. When she got to Harvard Law School in 1956, she was one of only 9 women in a class of 500 students. Harvard Law School, in fact, had only started admitting women a few years before, and they hadn't really gotten up to speed. She was certainly the only mother of a young child who was at Harvard Law School, and she treasured the escape that each side of what she was doing then, her taking care of her child and her doing her studying, she enjoyed both and thought they worked quite well together. But when she graduated from law school at the top of her class at Columbia, where she did her last year, She applied to many law firms in New York City, and none of them would take her. She felt that was in part certainly because she was a woman, but even more so because she was the mother of a young child. Nor was a clerkship easy to come by. She did get one, but she got it because a faculty mentor, Gerald Gunther, badgered a federal district court judge into taking her. He had a carrot and he had a stick. His carrot was, look, give her a try. And if you don't think she's adequate, I have a man lined up, a former student of ours, who will come in and take over. And if you don't take her, I'll see that Columbia Law School never sends you another law clerk. And so the judge hired her. Of course, he was extremely pleased with her work, and that was history. But she also had a shot at the Supreme Court of the United States because Al Sachs, a Harvard law professor who passed on recommendations for clerkships to Justice Frankfurter on the Supreme Court, recommended her for a clerkship with him. Frankfurter declined. He said that it wouldn't be right for him to hire the mother of a young child. When she got her teaching job at Rutgers in 1963, she became the second woman ever on that faculty. The first was hired the year before she got there. And get this, she was one of only 2 women hired in the entire United States onto a faculty of a law school. Indeed, Irma Hill Kay has tracked this down and determined that she was the 19th or 20th woman ever to be on a law faculty in the United States in its history. And the dean of the law school was a very kind, fine gentleman. He was also gay and with a partner, which was unusual in those days to know about. Nobody really talked about it out loud, but she thought he was quite wonderful. She nonetheless reports that when she was first hired, he told her that he would not be paying her as much as the men got because she had a husband earning a good living. And under those circumstances, she would be paid less. And one other thing I'll mention out of many I could bring up is that in 1965, a couple years into her teaching, she's not yet tenured at Rutgers. She gets pregnant unexpectedly, and fearing that she will be fired or that will not get her contract renewed, she hides her pregnancy. Fortunately, her mother-in-law, who she called Mother, was a little bigger than she was and loaned her some clothes, and she managed to get through the spring semester. It's, I guess it's still a problem in some ways, but back in those days, it wasn't just Ruth Ginsburg who was worried about being fired. It was absolutely standard practice throughout the country in many contexts, many work contexts, to terminate women employees when they got pregnant, and if they were a little more generous, just put them on mandatory leave for a number of months before and after the child was born, and then let them return to their job. All of this, of course, without pay. But those things, I have to say, did not turn Ruth Ginsburg into a feminist yet. She was a person who just took what came and tried to stick with it and proceed. And it didn't turn this procedure nerd into a feminist legal activist in an instant. But there were other influences, and I want to mention just two, and then get to the one that she claims is the real reason she became a litigator for women's rights. First, between her clerkship and her law teaching job, she spent 2 years working on a project on international procedure at the Columbia Law School. And she spent two months, and she spent several months of both years studying Swedish civil procedure and criminal procedure also in Sweden. And she learned to speak Swedish. And she read the daily newspaper to practice her Swedish. And in that newspaper was a column by a woman named Eva Moberg. And Eva Moberg wrote about the unfairness of assigning work, both on the job and in the home, on the basis of gender. Ruth said that made a deep impression on her, and it changed her own, she said, habits of thought. She also read Simone de Beauvoir's The Second Sex and Betty Friedan's 1963 bestseller, The Feminine Mystique. The feminist mystique, she said, was about frustrated housewives, and she wasn't ever a frustrated housewife. But The Second Sex, which dug deeply into Western civilization's gendered arrangements, impressed her greatly and influenced her thinking. But the thing she credits for getting her started was her students. And I want to say something that Drew will find familiar about the period of time in which students were doing that to their professors. This is 1969. She's got tenure. And all across the country, young men are being drafted into the service in the Vietnam War. And the law schools are scrambling for students. And the percentage of women magically begins to increase. And once that started happening, the women started getting vociferous. The percentage of women in law school rose from 3% to 10%. It was 10% when I was at Berkeley Law I graduated in 1970. And the school was very proud of its record of having 10% women in its incoming class that year. So here's Ruth. She's got these women students, and they are an interesting group. Many of them are, as I was, inspired to go into law in part because of the civil rights movement of the 1960s. And those of us who didn't have to work to stay in school even participated by traveling to the South and being a part of that. And so these women who were now gaining numbers were veterans of the civil rights movement, and they also tended to be, on average, older than the men who were there. Older because women were suddenly realizing, as I had realized, that they could really change the world if they went to law school. And when they showed up, the first thing they thought they should change was the law school itself. So 1969 was the year that women law students began to bring the feminist movement into the legal context. women's lib became women's legal rights. They established student organizations, first at NYU and then across the country in the law schools. Certainly, I was part of founding the first one at Berkeley. And they...
Wendy, one more minute.
Okay. And so what happened was that they were demanding more women on law faculties, more women students, changes in the curriculum, coverage in the law review, et cetera, et cetera. Ruth Ginsburg didn't just litigate in the Supreme Court. That she did during the night in her free time. She taught. She taught the first course on gender and law at Rutgers. The next year, she taught it at Harvard, commuted there to teach it. And she wrote a casebook. She participated in a conference at Yale, New Haven.
I was there.
Drew was there, and I was there, and Ruth Ginsburg was there, which is when we got our first exposure to her, I guess. And she was small and quiet and reserved and brilliant. And what happened from that conference was, it was a conference about teaching women in the law in law schools. And we all went home with these little bundles of references and ideas and things. And we all, I think almost all of us, taught courses on women in the law schools. I know I did at Stanford, and many others did too. So those were the things that were going on. She also worked with the association, the AALS, and was one of the people who was really instrumental in getting the ALS to change its policies on women. And she started her first case with her husband. The two of them got together and started their first case in 1971. And it was a case that became a movie. So if you want to know about that case, you go see the movie on RBG and her start in this process.
Well, maybe at this point we can ask you to engage our other two experts here on some of the things that you've talked about. So Margot and Ria, how about it? Got something to say about this? And Wendy, feel free to respond. We only have about 5 minutes for this portion.
I think that Justice Ginsburg was enormously empathetic, and as she became more of an authority on women's issues, there were certain aspects of women's situation that she had experienced, being things having to do with discrimination when she was pregnant, discrimination when she was looking for jobs, people thinking that she wasn't as smart as anybody should have known that she was, various kinds of assumptions about where her priorities were going to be and how useful she'd be in the workplace because she had a child and so on. I think as she experienced that stuff and began to expand her knowledge of the ways that the US Code discriminated against women, the ways that law, to kind of catalog all that stuff, she became a person who everybody talked to about how the law was restricting women's ability to flourish. And so I actually think that her own expertise was part of what drove her widening agenda. that she didn't just have an agenda that was premised on the parts of these matters that she experienced as a, as a white woman in New York, but became very broad indeed. And that was in part because she became kind of a focal point where people would explain to her what they were experiencing. And she was such an empathetic person that she was able to understand that in ways that, are really important in her development. So I think like her biography matters, and I don't mean to say that it doesn't, but I actually think for her, in some ways, her biography matters a little less than you might think, because she acquired information and an agenda from other people too.
That's such an important point, Margot. And
I would just add to that she didn't just sit around and listen politely. She was also empathy aside, she was also learning as much as she could by teaching a course in the subject. She wrote a case book. She expanded her expertise. She reached out. She reached out to the women's rights law firms that were popping up around the country and brought us together to meet from time to time. She showed up at the women in law conferences that went on until from 1960, well, that 71 until the last one in the 1990s. And she was a person who took positions where she could have an influence on what she was trying to get done and could support others to do it. She wasn't just absorbing and sympathizing.
Ria, you had wanted to jump in here too as well.
yeah, I just wanted to say it's such an important point, Margot, and it's one I think that Justice Ginsburg would have used to describe her own advocacy. There's a wonderful clip in the new documentary of Polly Murray called My Name is Polly Murray, which I recommend to everyone, where she's interviewed about, and asked the question, why did she put Polly Murray's name on the very first brief that Justice Ginsburg filed in the United States Supreme Court? And her answer is just remarkable. She says, well, I wasn't saying anything new. I was just saying the same things that Polly did. And the difference wasn't the arguments, it was the times had changed, right? Now I had an audience that was receptive, an audience that had not been receptive just a few years in the past. And I share that anecdote because I think, it's true that she was a great listener, but she also knew how to strategically deploy what she had heard, right? How to take that information and say, I'm taking in all this information and now I'm going to pick and choose, what is the world ready for me to say? What is the world ready to hear from me? What is going to land differently coming from me than it did coming from Polly Murray or even Thurgood Marshall? And how can I use the privilege that I do have to use that information strategically and to advance the cause of women's rights in an incremental way that will be solid and that will be very difficult to undo.
Just to add in one thing, my mother was a friend of Ruth Bader Ginsburg and was a feminist medical school professor and speaker. And in the eulogy that Justice Ginsburg did at my mother's memorial service, she basically said something which really colors so much of what Ginsburg's work centered on, that real advancement of women cannot come out without understanding the problems of both men and women and the harmful stereotypes that impede both from realizing their full human potential. And I know that all of our panelists are going to focus in on how that affected the cases that she selected to get involved in and the ways that she was able to ultimately change the reality. Well, let me move on now to our next distinguished speaker, Professor Margot Schlanger, graduated from Yale Law School some 20 years after Wendy and I became civil rights lawyers. She was ultimately appointed to not one, but two endowed chairs. I couldn't help notice on that website of theirs at the University of Michigan Law School. She earlier had the honor of clerking for Justice Ginsburg during the justice's first 2 years as a Supreme Court justice from 1993 to 1995. And And Margaret, I have to say, among your literally dozens of scholarly articles and those in the popular press, I was taken by the one that was entitled In Time magazine. I was one of Justice Ginsburg's first law clerks. The experience shaped my career and my marriage. But moving right on, and you are, of course, a nationally prominent civil rights scholar, litigator, and distinguished speaker in areas especially including prison reform and immigration reform. Professor Schlanger founded and directs at Michigan the Civil Rights Litigation Clearinghouse. Her very considerable public service has included presidential appointment to be the Officer for Civil Rights and Civil Liberties at the Department of Homeland Security. And one last factoid before I ask you your question, I was struck by the fact that you were a fact checker for the New Yorker, which no doubt made subsequent legal research and cite and source checking, a kind of a walk in the park. But anyhow, my question to you is, did it make a difference that Justice Ginsburg was not just a women's rights litigator, but more generally a civil rights lawyer? And if so, how? And needless to say, along the way, we would love to hear some of your personal reminiscences about your clerkship and its sequelae.
Sure. So I think that it's really, when you think about Ruth Bader Ginsburg as a lawyer in the years from 1970 to 1980, basically, when she became a judge, right? It's a 10-year span where she was very much a lawyer. It's really important to understand that she was embedded in a community of lawyers. She was very much embedded in the women's rights community, no question about it. That's what Wendy was just talking about. But she was also embedded in a broader group of civil rights lawyers. The Women's Rights Project was part of the ACLU, and the ACLU was at the forefront of civil rights litigation as a way of achieving something closer to equality, not just for women, but for lots and lots of different kinds of people in lots of different ways. The ACLU, for example, was the sponsor of the first national prisoners' rights litigating organization, just for example. The ACLU did an enormous amount of race equality litigation. The ACLU was, the connection to the ACLU put later Justice Ginsburg in a community of lawyers as a colleague and a sort of reference group that was very broad. And so when she became a judge, she joined the fairly select group of judges who used to be civil rights lawyers. I mean, now, just to be clear, judges who used to be women's rights activists is even smaller. I don't, right? But judges who used to be civil rights lawyers, that's a little group. And when she became a Supreme Court justice in 1993, she became one of two justices who were, before they were judges, civil rights lawyers, Ruth Bader Ginsburg and Thurgood Marshall. Now, I don't mean to say that therefore those two people were the most progressive justices in the history of the Supreme Court. By some measures, maybe they were, by others, not so much. But I do mean to say that that RBG's approach to the law was the approach of a civil rights lawyer. And what that meant was two things, I think. One, a belief in the potential for law to change the world and achieve something really important. Two, the absolute focus as the prime value of American constitutionalism on equality. And I think those are both really, you can't really talk about two pole stars, but they are guides to her jurisprudence. And so when she became a judge, when she became a justice, she was really rock solid, not just on women's rights, but on civil rights more generally. So for example, I went and I was thinking about the years that I clerked. So in 1994, in the 1994 term, I confess, I don't actually remember if this was 94 or 95 after that, but it was the 94 term. She dissented in Missouri versus Jenkins, which was a school deseg case, and in Adirond, which was an affirmative action case. And in both of those cases, she emphasized that, I'll just quote one sentence. She said, we need to remember in Missouri v. Jenkins, when the court was shutting down some important some important school desegregation moves. She said, we need to remember that compared to more than 2 centuries of firmly entrenched official discrimination, the experience with the desegregation remedies ordered by the district court has been evanescent. And then in Adirond, she had this amazing paragraph. I urge you all to go look it up. I'll try to paste later the citation. But she had this amazing paragraph about how race matters now. That don't you be thinking that we're done, that we're post-racial. We're nowhere near post-racial, she explained in her dissent in Adirond. And I think she was really conscious of that stuff. She was conscious of also a whole host of other issues that I likewise think of as civil rights issues. So when I clerked for RBG, which was for 2 years from 93 to 95, that was before I got involved in anything to do with prisons. But I remember she got quite deeply involved in prison reform in her time in Sweden, actually. I remember meeting somebody from Helsinki Watch, which was a group that she had done some work with before she was a judge, who she introduced me to. And I remember chatting with her husband, Marty Ginsburg, who was, a fantastic tax lawyer and a tax professor. And it just sort of hanging out one time. It was probably at one of the dinners that she had Marty cook for her law clerks every so often. Marty was a terrific cook, but I don't remember quite when it was. But I remember saying they were about to go on a trip, and it must have been the end of the term. So, and I said, so, what are you going to do while you're in wherever? And he said, well, I don't think we'll do this time, but I will say that other people, when they go on vacation, they golf, they go to museums. And when we go on vacation, we often go to prisons. And I don't know that people really know how committed she was to prison reform. It wasn't a commitment that guided her jurisprudence particularly. She didn't litigate those cases. She didn't decide all that many of them as a judge where she wrote. She wasn't typically the fifth vote on those cases. And so even when she was assigning, you sort of assign to the person who's the squishiest a little bit. And she wasn't squishy at all on those cases. And so she didn't write that many of them. She was really committed to the idea that prisons had to be more humane than they were. And she used to, before she was a Supreme Court justice, she used to take her law clerks on a visit to federal prisons so they would understand the stakes in criminal law cases. She had to stop doing that when she became a justice because it would have been a circus. But she used to do that. And that's likewise, I think, something that came from her heart, but also that came from her embeddedness in civil rights movement that she was very much a part of. So I think that it really does matter that she was a civil rights lawyer. And I think that she is one of the kind of cases in point to help make a point that a number of advocates are making right now, which is that for too long, there's been this idea that judges mostly come from big law and prosecutors' offices. That the thing you do if you want to be a judge is you become a partner at a fancy law firm and you do an occasional pro bono case to demonstrate that you have some interest in public service, right? Or you become a prosecutor, likewise for the public service. And it's not that I don't think that those are valuable ways to contribute to the American bar, and I do. But I think that being a civil rights lawyer is also a really important way to contribute to American society and the American bar. And that we should remember, like, we could do a lot worse than have more justices and judges at district courts and at courts of appeals than Thurgood Marshall and Ruth Bader Ginsburg. And like, she really should be a reminder that, and I think she is currently being a reminder to the people who are making decisions. There's been a lot of talk about maybe we should broaden out what we think of as appropriate backgrounds for judges. And like, I hope that keeps happening. And I hope that really bears some fruit. And I hope that one of the fruits it bears, or many of the fruits that it bears, are little Ruth Bader Ginsburgs. Somebody just wrote a note that says, what about public defenders? And I totally agree, and public defenders too, but I don't know that you can take RBG as a model for the idea that one should name public defenders to the bench. I'm totally for it, but I don't think she's not the model for that. There are other models for that.
So how about Maria?
Sure. Well, I'll just react to a few things Margot raised, which of course I feel I have a bit of a vested interest in as a current ACLU lawyer. So I'll just remind everyone of that fact at the outset. But the first bit is that, it didn't just happen that RBG founded the Women's Rights Project within the ACLU. She was quite intentional about that choice. And I feel like I'm a bit of a broken record, but I think it's so important to remember that everything she did was so carefully thought out. It did not just happen. It was not like, here I am at the ACLU and what a happy coincidence that I'm surrounded by all these other wonderful civil rights lawyers. She chose the ACLU as the place to found the Women's Rights Project because she firmly believed that in order for the women's rights movement to be successful, at least in the law, that it needed to be interrelated with other civil rights movements, that was part of the strategy. And I think you see that not only in her time as a judge, but even in the cases that she litigated during her ACLU years, to name just a couple of examples. Really ahead of her time in terms of the intersectional understanding of the ways that sexism and racism can combine. A case that I've written about that she litigated challenging North Carolina's forced sterilization program that was directed primarily at young Black women, people with mental disabilities. The amicus brief that she wrote in Coker v. Georgia, arguing that the death penalty for the conviction of rape was unconstitutional. I commend everybody to hop off this call and get on Westlaw and read this brief because it's truly remarkable to understand the way in which, in the 1970s, we have Ruth Bader Ginsburg saying, the notion of the death penalty for rape is based on sexist tropes about white women's fragility. And that it is both sex stereotypes and it is racism directed at Black men that have combined to make the death penalty for rape as common as it is. And those are the same reasons why the court should not uphold it. So it's really remarkable to go back and read that and to think about that brief being filed in 1973. And then I just want to say one thing about her time on the bench, or I guess a couple of things. One is that it's not just that she was the only civil rights lawyer, right? It's that when you think about the other justices, even the progressive justices, it's not just that they were not civil rights lawyers, but by and large, they were all government lawyers. They were people who either were prosecutors or perhaps worked at the Solicitor General's office. So she is the only one who represented the person on the other side of the V who sues the government, which of course is something that we at the ACLU have made a career of doing. But I think that perspective is really quite unique beyond just the fact that the subject matter was civil rights, but she was little guy or little gal against the United States. And that perspective really shines through in so many of her opinions, but one that's very near and dear to my heart is her dissent in Masterpiece Cake Shop, a case that the ACLU litigated. And when you read her dissent in Masterpiece Cake Shop, it's clear that she intuitively understood what the case was about. She intuitively understood, of course, she was not in a same-sex marriage, but she intuitively understood what it was to be turned away because of who you are, to be told your dollar is not good enough. Because she knew it because she had lived it herself. She herself had been turned away because she was a woman or because she was pregnant. And so she didn't need to reach all that far into the depths of her imagination to understand the significance of the case, both for Dave and Charlie, the clients in the case, and really for all of us and the world that we want to live in, free from gender stereotypes, where all of us can be free to go about our daily business without that fear of being turned away simply because of who we are. And I don't think there's another justice on the court who had both lived that reality and litigated that reality, right? She brings those twin experiences, the personal and the professional experience. And that combination, I think, is what has made her such a blockbuster force on the court.
Wendy, 1 minute of feedback here.
1 minute and two issues that Margot reminded me of. She mentioned the Adirond case and Ruth's feel for the issues of race discrimination. And I want to just mention the Shelby case from 2013, in which she wrote this fierce dissent. It was a challenge to the Voting Rights Act provision that said that states that historically had passed blacks from voting, had to pre-clear with the Justice Department any new law they made respecting that area. So what happened was in Shelby is the court did the wrong thing. It said it's no longer necessary. This isn't right to have these states have to be pre-cleared before they make their voting legislation. And in Shelby, she said, and I'm sort of, this is not a direct quote, but this is the general idea. She said, look, this taking away the pre-clearance is like walking along in a rainstorm with an umbrella. And because you're not getting wet, you close the umbrella. And the day after that case came down, states that were no longer under pre-clearance started changing their laws and making voting harder for African Americans. That's one. The other is, I just wanted to say that on the death penalty, she wanted to stay in the debate, so she didn't automatically just say she opposed the death penalty. But she was very skeptical of it, and it hurt her every time she had to deal with a death penalty case in the Supreme Court.
Margot, did you want to respond to any of this for a minute?
I think all of this is true. I think that I think it's really important to have on all of our courts people from a variety of perspectives. The idea isn't that no one who's, I was a civil rights lawyer for the government for a chunk of my career. So I certainly think one can work for the government and be a civil rights lawyer, but I've also been a civil rights lawyer not for the government. And those are very different perspectives. Representing individuals and representing the United States are not the same. I think that I think you really want judges who have a variety of practice backgrounds, and that we are vastly the richer for it if we don't sort of just have judges in one model. And I think she demonstrates that.
My husband just leaned over and said nobody's talked about the fact that she was Jewish, and this is not a country that has what could be called a stellar record in that regard. And perhaps in later remarks, people can address that. To some degree, I did want to say, as I start to introduce you, Rhea, that I was the first woman chair of the ACLU of Northern California because a nationally prominent prison rights lawyer, my husband's first wife, Faye Stender, basically took over the nominating committee and made it happen and brought a group of women and people of color and people from the LGBTQ community onto the board of the ACLU for the first time in Northern California. So all of these issues sort of come together. All right, a graduate of NYU Law School, Rhea Tobacco-Marr is a director of the aforesaid ACLU Women's Rights Project. She previously served as a staff attorney with the ACLU's Lesbian, Gay, Bisexual, Transgender, and HIV Project, where she led the ACLU's team in the Masterpiece Cake Shop case that she mentioned earlier. She earlier clerked for the Sixth Circuit and the Southern District of New York, and was an associate at one of New York's most prominent, and one would have to say, most kind of hidebound in certain ways at that time, certainly, law firms, Cravath, Swain, and more. She served also as a staff attorney at the legendary NAACP Legal Defense and Educational Fund. She is a frequent commentator on gender justice issues and has appeared on all kinds of TV programs, as have our other two speakers. In Rhea's case, including All In with Chris Hayes, Politics Nation with Al Sharpton, PBS's Firing Line with Margaret Hoover, and she has authored many, many opinion pieces for newspapers, including the New York Times and the Washington Post. She's also been recognized on these recognition lists of lawyers that are a whole lot younger than Wendy and me. She's been recognized on the Route 100 annual list of the most influential African Americans aged 25 to 45, and one of the best LGBT lawyers under 40 by the National LGBT Bar Association. I have to say, Rhea, before I ask your question, that I followed a few of your tweets now that my daughter has taught me how to do this kind of thing. And my favorite of all of yours is, quote, to the person who asked if I like Girl Scouts lemonade cookies, I don't know, but I do know that I ate the entire package trying to decide. And with that, tell us a little bit, Rhea, about the docket of the ACLU Women's Rights Project today, 50 years after Ruth Bader Ginsburg, with great deliberation, was the founding lawyer and director. And how is your docket similar, if at all, and how is it different from what the docket was in the early 1970s? And also, do you see Justice Ginsburg's influence in your current work? Among some of the kinds of things that I have seen her quoted as saying to her law clerks are, leave tracks, use your education to help repair the tears in your community, ensure the health and well-being of your generation and those to follow, stuff like that. So, you're on.
Sure thing. And before I get started, I just wanted to say I did see some folks asking in the chat for citations, and I think we can chat all of you. So once I'm done with my bit, I'll try to pull some of those for folks, or maybe someone else can do it. Thank you for that very embarrassing introduction, Drew, especially about my Girl Scout cookie addiction, which I feel there are so few vices left to us in the pandemic that Girl Scout cookies are quite high on my list. When I think about the docket of the Women's Rights Project today, I think, in some ways it's more similar to the docket that it was in RBG's day than you might expect. And I'm not quite sure whether that's a sign of pessimism because of a lack of progress, or rather reflects the fact that she was so ahead of her time and groundbreaking that the same strategies actually ought to be employed against the problems that we're facing today. So I'll just give a couple of examples and then turn it over to my co-panelists. One is, in many ways, the greatest legacy of RBG's time in the Women's Rights Project was the, establishing that heightened scrutiny applies to gender classifications under the Equal Protection Clause. And I know this is an obvious point, but
a little bit, Rhea, that particular remark for those who are not experts on women in the constitutional law.
Sure. Well, it hasn't come up yet. I sort of thought we'd have gotten here by my time in the program, but when RBG began to litigate, the Supreme Court had never seen a sex classification that it did not uphold. It had upheld state laws, for example, protecting women from tending bar unless their husband or father owned the establishment. It had upheld laws protecting women from serving on juries because, of course, their proper role was at home. So it had upheld a whole range of ways in which state laws expressly discriminated against women, often in the name of protecting them in a way that came to be known as benign paternalism. So this notion that the Equal Protection Clause, just as it required more searching scrutiny of classifications based on race, also required more searching scrutiny for classifications based on sex, as RBG said, was pioneered by Pauli Murray, but it was RBG whose time was right to make that argument before the United States Supreme Court, and who succeeded in a series of cases from 1973 and on in convincing the court to actually begin to strike down sex classifications under this intermediate standard of review that the court established in cases that she argued. And if there were any doubt after her time in the Women's Rights Project that that was the case, she cemented it on the bench in her decision in United States versus Virginia, the case involving the Virginia Military Institute's policy of excluding women, in which she applied heightened scrutiny and famously said that VMI could not exclude women. And to be sure, most women would not want to attend VMI, but then most men don't want to attend VMI either. And the question for the Equal Protection Clause is, for the person who does want to go, right, is there a compelling government interest that's sufficiently tailored to justify keeping them out? And in the VMI case, the answer to that question was no. The reason I've spent so much time on heightened scrutiny is just to say that Though if you read the decision in VMI, it seems quite clear that heightened scrutiny applies to all government classifications. We still today are litigating cases where the government is arguing that heightened scrutiny ought not to apply to the sex classification for one reason or another. And I'll give just two examples, but I think it's really devastating when you think about the significance of that argument toward undoing Justice Ginsburg's legacy, or the fact that the government would never make that argument when it comes to other characteristics that raise a heightened level of review, like national origin. So this notion that somehow sex differences are more real or more enduring than other forms of difference between us is really quite damaging. So again, just to give two examples, we are still litigating a case that was originally filed in 2012 challenging the exclusion of women from combat roles in the military. This was a case brought on behalf of women who wanted to serve in combat roles, which is, as those of you with a military background may know, really the chief way one can advance in a career in the military is to serve in those positions. And though the government caved very soon after we filed our lawsuit, it has persisted to this day in various policies aimed at integration that essentially keep women out of units unless and until senior women are already installed there. And this notion that essentially you can't have a junior woman unless you have at least two women there first, which doesn't sound quite so outrageous until you imagine, for example, they said, well, we can't put a Protestant in this unit until we have two others first. And then suddenly it seems laughable that we would take that into account, or that the government would even make that argument in court. But when it comes to sex, the government is, in fact, making that argument in court. And if it were to be accepted, as I said, really could do quite a bit of damage. Another context that we're litigating in a case that's going to be argued by one of my colleagues in the Fourth Circuit tomorrow involves a public charter school that requires girls to wear skirts as a condition of attending school. And this is a context, again, in which we have the public school arguing, yes, sure, it's a sex classification, but heightened scrutiny shouldn't apply because it's a dress code. Well, again, if the school had a policy that said Protestants wear blue shirts and Muslims wear green shirts, I think we would think that was a pretty significant problem. But somehow when it comes to sex, we are still seeing the government make this argument that somehow sex is different, that heightened scrutiny does not always apply, and that Justice Ginsburg did not mean what she said. And I'm certain that she's with us, shaking her fist at these arguments, but the persistence of them and the fact that we still need to fight these battles today, I think just shows what an uphill battle it is really to fully eradicate that sort of long tail of sex stereotypes. And just to name very quickly, because I see we're short on time, other contexts, I heard Wendy talk about Justice Ginsburg hiding her pregnancy. Of course, pregnancy discrimination remains very rampant in the workplace today. And we have a significant docket in that space, which I think, again, would be near and dear to Justice Ginsburg's heart, although it's a place where the courts have really let us down. The Supreme Court twice has said that pregnancy discrimination is not sex discrimination, something Justice Ginsburg has said she disagreed with, and which has caused Congress to step in and try to fix the problem, but it's done so in an insufficient way. And so what we've seen is the Pregnancy Discrimination Act of 1978, which was Congress's attempt to fix what it saw as a wrong-headed Supreme Court decision, saying that pregnancy discrimination is not sex discrimination. But the Pregnancy Discrimination Act requires employers to treat pregnant workers only as well as it treats other workers. It still allows the employers to treat everyone poorly. And when it comes to pregnancy and when it comes to employers in this country, we see so many employers who are saying, we treat everyone terribly. You need to bring a water bottle with you on the sales floor. Too bad, can't do it. You have a lifting restriction. Too bad, can't do it. And what we've had to do is really litigate those cases sort of case by case and circuit by circuit to establish what should be, I think, a common sense principle and what Congress likely intended when it passed the Pregnancy Discrimination Act, which is, of course, that no one should have to choose between a healthy pregnancy and the ability to earn a living. I am cautiously optimistic that the Pregnant Workers Fairness Act, a fix currently pending in Congress, could be enacted as early as this year and will be a huge fix for that problem. But until then, that remains sort of a big part of our docket. And then finally, I'll just say we still remain very attuned to issues that are faced by Black women and other women of color in particular, which, as I mentioned, is sort of a lesser known area of RBG's work, but really was quite significant to her focus and her time at the Women's Rights Project. So I think it's important both to name her interest in this space and also to share just some of the work we're doing currently very much in the area of housing justice and evictions, a question that's often thought of as an economic justice issue, perhaps a racial justice issue, but not always as a gender justice issue. despite the fact that Black women are evicted at twice the rate of other renters. We know very much this is a gender justice issue, and the impact on women and families who are forced from their homes, particularly in the middle of a pandemic, will have far-reaching consequences for these families in the future, destabilizing employment, destabilizing school, and placing the family at risk of never being able to rent another proper apartment again. So I share that with you just as one example of work that I think looks in some ways quite different from work that RBG did in the Women's Rights Project, and at the same time is responsive to the issues faced by Black women and other women of color today in a way that I think would have been very close to her heart.
Thank you very much. Wendy and Margot, your feedback or contributions on some of the issues raised by Ria.
Yeah, so I think that what Ria was just describing is a really proud legacy of the justice. And so, and I think she believed in the ever expanding idea of we the people, is the way that she would often phrase it. And I think she probably, she also believed in the expanding vision of what it takes to ensure equality for women in a similar way. I just because you asked me to tell stories, I'll tell one very, very short story, which is that my husband represented Peggy Young in Young versus UPS, which was a pregnancy accommodation case in front of the Supreme Court. And he also clerked for Justice Ginsburg 2 years after I did. In some way, she introduced us, which was the origin of that time story that you quoted, Giselle. But the point is just that, they didn't discuss the case. She was hearing it as a sitting justice. So it's not like they talked about it, but she did at the end send him a really nice note with a copy of the slip opinion, telling him, I don't remember the exact phrasing, but basically, I think that she knew that pregnancy accommodation was at the core of women's equality, women's economic equality, and women's social equality. She wrote that in Coleman versus Maryland Court of Appeals, which was the case where she said, it's outrageous that pregnancy discrimination is not considered sex discrimination. And we need to fix that. And where she explained her vision of how important pregnancy accommodation was to equality. And then, as I say, my husband got this really nice note from her where she said the same thing after the case was decided. So I just think, I think that pregnancy accommodation is really one of the places where the women's equality fight is just so far from won. And it's one that she saw from the get-go had to be included. And so I just think it's great that that's such a key focus for the ACLU now.
Thank you. A minute or two of comments you might have here.
Yes, I think watching her in action in real life speaks volumes too. Ria, you probably know this, but right after gay marriage became legal, she began performing gay marriages for her friends who were gay and who had waited years and years to get married. And I think that she didn't say anything about it. There was no publications about it. It wasn't in the newspapers. She put her money where her mouth was, in the sense of treating every human being with dignity and respect and equality. And I think she'd be very distressed if right now she had to look at where the court's going on the issue of religion and the First Amendment, because she used to say, and has said in one of her opinions, that your right to religion stops right where my nose starts. In other words, you can't do anything you want to me just because religiously you want to do it. And right now, the Supreme Court of the United States is expanding the idea of people's religious rights under the First Amendment to an extent that deprives others of their rights. And it's a position that she took and would take if she were still with us. I just want to remind everybody that this is the month she was born. Her birthday is coming up. She would have been 89, I guess. And this isn't this Women's Equality Month?
Yes.
It's an
Women's
so-
History Month, but I like your rebranding, Wendy. I'll take it.
Thank you.
Well, at this point, we have some questions, and they're directed because I asked people to one particular person, but we have the time for other people to jump in. I cannot. The first question really is to Professor Schlanger about working as a clerk and how she used her clerks and how much you really were involved in the reasoning and the ultimate drafting of opinions and so on, and what you learned as her clerk. And I just wanted to touch on one aspect. I ran the National Association of Women Judges at one point, and it was astonishing to me how important that organization was to Justice Ginsburg and to Justice O'Connor, and later Sotomayor and
Megan.
yes, and a moment. But you know, she. Everyone on this panel knows about how incredibly kind she was to friends and to friends of friends and to children of friends. And I simply have to tell this anecdote because it's so weird. I had moved to New York. My mother was a friend of hers, so she knew I'd moved to New York at one point, and we didn't know that many people. And so one day our phone rings, and it is a youngish woman who has a pretty average name, who says, I understand you're relatively new in New York. Would you and your husband like to come over to dinner? And at some point, I had no idea who this was, none. And you know, there's a point where you can say, "Excuse me, who is this?" And then when that point passes, you're dead. Well, it passed. So we went to their house for dinner. It was she. It was her husband. There was nobody else there. We went all the way through dinner having no idea who they were or why we were there. And then the crowning moment was when she mentioned that her mother, when she had graduated from law school, had not gotten a single offer from a law firm. And she left the room, and I said to her husband, well, is Jane's mother still practicing law? And of course, he looked at me as if I had taken utter leave of my senses and said, Jane's mother sits on the United States Supreme Court. It was a bad moment, a really bad. He later said, do you go to anybody's house, any Tom, Dick, or Harry asked you? I said, well, pretty much. But in any event, it was her kindness in asking her daughter to be kind to people that they had never met, and they never met. Well, she did know my mother. Jane didn't know my mother. But I saw that as just absolutely typical of the kindness that she extended. And so I guess we'll start, Margot, with the questions specifically to you, but then have the other panelists talk a little about that kind of issue.
So what the two parts of what law clerks did, I mean, I don't really know if RBG continued exactly the same way. I know she did for a while, but I don't know that she did last year, the year before. But what she did when I was clerking was we wrote bench memos for the argued cases. And what she told us about the bench memos was that the goal was so that she could read the key briefs only once. So the idea was you read once to kind of get oriented, and then again to really be analytic about things. And the idea of the bench memo was to orient her so that she could get away with reading everything one time instead of twice. So it was to orient her, as I say. On drafting, she would tend to do some combination of a conversation, an outline. Maybe she'd write the first paragraph, something like that. And then you'd take a stab at doing a draft. And then she would write all over it. And, would sort of the red ink would be sort of overwhelming. But again, the idea was that so that she would have something to edit rather than having to write from scratch. And she found that that was conducive to getting the work done more effectively. It was, so I never really mastered writing like her. Some of my colleagues did. They learned to use words like mime run and path marking and so on a little bit better than I did. She was very spare of prose, and so you tried to do that. One thing that the law clerks did do was, I'll just do one fast example. Her very first concurrence, her very first opinion at the Supreme Court was in it was a Title VII case, a sex discrimination case about gender-based harassment. And the question in the case, this was, what was it called? Well, I'll come up with it in a second. But the question in the case was, how badly injured does a woman need to be before she can have a claim for sex discrimination from a hostile work environment? And the Sixth Circuit had said she has to be badly enough injured that she sought mental health treatment. So she has to be really damaged. Okay, really, like, she can't be strong and resilient and nonetheless have been subjected to something illegal. Not that seeking mental health treatment is a sign that you're not strong and resilient, but what if she's good? It's just that she thinks that it's outrageous that people were getting in her way. So I remember on that case that the thing that I did, it wasn't so much the drafting, but I went looking for standards that she could say, that she could say, yeah, that's the right one. And I read all the case law on Title VII and gender-based hostile work environments. And I found one case in particular where I was like, that seems like it's consonant with the statutory text. It's a good standard. Like, that's the one. And so what I mostly did for her in that case was I reproduced this opinion, which said the standard is, did the harassment rise to the level that it made it harder for her to do her job? If it made it harder for her to do her job, then it altered the terms and conditions of employment. And that's what the statute says, and that's illegal. And she liked that standard and said, yep, that's the standard. And she put it in a concurrence. And eventually that concurrence was adopted as the Supreme Court's rule. But so my contribution there was not deciding. It wasn't even really analysis. It was the digging work I was a little bit analysis, right? Because I liked that standard too. So I was sort of proud of myself, but nonetheless, like you were very much her assistant in doing it. We didn't have any delusions of grandeur that we were junior judges, or like that would have been crazy. She was very much her own person, and her law clerks helped her do her job faster and hopefully helped her do her job a little bit more kind of capaciously, but that was our role.
Other comments?
Well, I am impressed with how many thank you notes she wrote in her lifetime. You did something for her and you would get a note, handwritten with her left hand. She was a lefty. And I have a lot of those notes. It's just amazing. And I've gone through all her files and things at the Library of Congress. She was a person who liked to say thank you to people for what they had done. She also likes to send onesies with Ruth Ginsburg on the front to babies. My grandchild.
Ruth Ginsburg Grand Clerk was the one that she used to send to her law clerks. I have twins. When they were they're 21 now, but when they were one, they had Ruth Ginsburg Grand Clerk onesies. They were adorable.
Well, she's still doing it because my first grandchild, who's now 2, had a onesie from Ruth Ginsburg.
Cute. The case I was thinking of is Harris versus Forklift Systems. I'm kind of embarrassed that I couldn't just come up with it. Sorry.
Well, at least you knew all the justices on the Supreme Court, for God's sake. Ria, any comments in connection with this conversation?
I don't think I can top Margot's personal experience, though I will say that I also have twins. So Margot, you're giving me hope. Mine are only 4 years old. But
oh, it gets so much better.
My first child was like having twins.
We have a question that is on a different topic. The question is, I hear that Justice Ginsburg had suggested that if the country was starting over, she would consider the South African Constitution as better than the US Constitution. Any thoughts on that?
You know,
She
I can, oh, go ahead, Wendy, sorry.
Go
She
ahead.
got a lot of grief for saying that. But her point was that modern constitutions take into account and address the problems of a wider and the rights of a wider group of human beings, and that we could learn something from them. She's always been an internationalist. She's always found looking at what other countries do as being very informative and worth learning. And this is just part of that.
She was a very big believer in transnational judge associations. She was quite involved in them. She felt like she learned a lot from them. She liked hosting judges from other places. She liked going to conferences with judges from other places. She thought that to ignore the wisdom that was developing in other countries, even if they didn't have our exact institutions or you know, they weren't interpreting the same text of the Constitution, she thought there was a lot of wisdom there. And it wasn't just something she said, she actually like committed real time to it. And one time there was a misunderstanding about a date, and the Chief Justice of Pakistan, if I'm remembering correctly, came and dropped by chambers, and she hadn't reserved the time for him because there was this misunderstanding about the date. And she made her law clerk show him around, and it was like it was just the heat of the summer, and court wasn't in session. And I remember at least two of us were wearing shorts, which was really embarrassing. And but she's like, he doesn't care. And she had to show him around. I'm not sure that he didn't care, actually. I think maybe he did a little, but I couldn't swear to that. Anyway, the point is that then she like found some time and chatted with him, but she spent a lot of time on the interaction with jurists from other countries.
Drew, you're
Muted,
muted.
Drew.
Next question, thank you. Given that so many trans men and non-binary people experience pregnancy, how would you describe pregnancy discrimination as gender discrimination without misgendering or excluding them? Anyone want to go for that question?
Sure, I'll go first. I mean, I think the answer is that pregnancy discrimination is really discrimination that is targeted at sex, even though that doesn't mean that all women must be pregnant or that only women must be pregnant, but that it's linked in that sense. Certainly the animus and the discrimination is linked. And, you know, I think the best support for this in the court in some ways comes from Justice Scalia. And I see there's another question about him because he has a famous line in Bray versus Alexandria, where he says, you know, a tax on yarmulkes is a tax on Jews, right? It's not that all Jews wear yarmulkes, and it's not that only Jews wear yarmulkes. If I, for example, you know, attend a religious service, though I'm not Jewish myself, I might put one on. But nonetheless, if the legislature singles out yarmulkes for disfavorable treatment, we can infer from that animus against people who are Jewish. And I think the same thing is really true when it comes to discrimination based on pregnancy, or for that matter, you know, menstruation. This is an issue that's very much of the moment because there's a lot of movement in the fight around menstrual equity to end the tampon tax and to make menstrual products, you know, free and available to people who need them in places like schools and prisons, right? It's not that every woman menstruates or that only women menstruate. There are a whole host of reasons why women might not menstruate. It could be a postmenopausal. She could be trans. She could have had a hysterectomy. Right, but that doesn't make it any less sex discrimination. The fit does not have to be, I think, 100% to prove a case of discrimination.
Yeah, I agree with that. The sociological point is that pregnancy discrimination is a big part of inequality of women, and that the two are bound together, the intentionality is bound together, the animus is bound together, and the impact is very much disproportionate on women. The point is not that all women get pregnant or that only women get pregnant, or the point is kind of as Justice Ginsburg might have said, it's the mine run of cases, and that matters. So I don't think she would have had any problem acknowledging that trans men can have babies. I don't think that lessens the analysis particularly.
How does childcare play into any of this? Did you know whether the justice had any opinions that touched on that, or had views that that obviously is integral to the subject that you're talking about right now? Anyone?
Well, I mean, think about the Weisenberger case, right? So, like the foundational among the foundational cases that she was thinking about were cases in which the government expressed a preference about who should do the child care. So I think it was there's two different kind of modes of analysis here that mattered to her. One is, it's really not any of the state's business who does the childcare. We are going to have a more equal and a better society if childcare is distributed without respect to who's the mother and who's the father and which parent gets it. And she used to talk a lot about how, she'd get calls when her son was getting in trouble at school, and she told them that they should call Marty half the time. And then all of a sudden the call stops because people didn't think it was important enough to bother a man at work. It was only important enough to bother a woman at work. But so she was a big believer in even equal distribution. She was also a big believer that it wasn't any of the state's business how that distribution happened, and that it was not, this is the idea that animates the VMI decision, that it's not the state's job to tell you how to be a woman, that you get to decide what kind of woman you want to be. And if you want to be a domestic, child-focused, at-home kind of a woman, fantastic. And if you want to not do that, that's also fantastic. It's not the state's job to tell you what kind of woman to be or what kind of a man to be. And the child care issues they have to do with both of those.
Yeah, just picking up on the second point of your answer, Margot, I think it's so important to emphasize it's not just that she wanted women to have more of an opportunity to step out of caregiving roles and into the workforce, though of course she did. But she also wanted men to have the opportunity to step into those roles, right? That everyone should have the opportunity to share both in, the labor, but also the very great joy, of caregiving and family life, something that she felt very keenly that so many men of her generation did not have that experience, and that their lives were the poorer for it. So I think it's really right when we think about her fight for gender justice, really as advancing the rights of all of us to be free from the kind of stereotypes that Margot described. What does it mean to be a woman, and what does it mean to be a man, and to each be free to choose.
She was very fond of a book written by Marlowe somebody called Free to Be You and Me. And her larger point, and she'd quote it and things. She liked it because the whole idea was be who you are and have it respected. And whatever the way you manifest your gender or your preferences for childcare or whatever it is, it's a decision that you should be able to make without the law intervening to tell you that's not your role in life. Her whole basic understanding goes to the center of the structure of gender historically, which was sex role pigeonholing, as she called it. There were things women should do, there were things men should do, and never the twain should meet. And for her, it was a matter of taking away the way the law reinforced it through its rules and forced people to be somebody they weren't. And also, I think it's important to say that she, she herself understood what it was like to be at the edge of what the roles should be back in the day, back in her growing up. She was Jewish. She wanted, for example, to be bar mitzvahed like her cousin who was about her age. And, but that was reserved for boys. Girls had a milquetoast version of it that they got, but that, that upset her. And I think her understanding of the whole structure of gender, the family structure at the heart of it, and how that was manifested in the law, that was what she was targeting. And she meant by that, how should I put this? That it was true that women were second-class citizens, and but men got discriminated against too, often because of a discrimination against women. And the Wiesenfeld case was really wonderful because when I watched her make that argument, she stood up and she began the argument by saying, there are 3 people who were discriminated against here. The plaintiff, Mr. Wiesenfeld, his wife, who died in childbirth, and his child, who needs to be taken care of by his only living parent. And so she saw it as a damage to men as well as women, and the freedom of all of us. And I think that was at the center of her concept.
No, we're almost at the end now, and I thought maybe I'd close this with a quote that most of you have probably seen from Senator Tammy Duckworth, where she said after Justice Ginsburg died, she said, with every case she argued, with every ruling she issued, with every dissent she penned, Justice Ginsburg helped push our country toward that more perfect union our founders once wrote on in the Constitution that she loved so fiercely. She gave me the chance to achieve my life as it is today, but her passing isn't just heartbreaking for me and for countless other women across the country. It's a loss for our entire nation, for justice, and for equality. And I would like to thank all of you out there in Zoom land for joining us for this discussion. I'd also like to express our deepest gratitude of the ABA for this remarkable group of panelists who have taken time out of their impossible schedules to share some of their personal and professional knowledge of Justice Ginsburg and everything that she stood for. You all are doing critical work, and we are honored that you joined us. I am duty bound to say that the section of Civil Rights and Social Justice of the ABA provides a lot of free webinars and resources for legal professionals and advocates nationwide and internationally. And we hope that it has helped some of you who are on this program today in your work. And we urge you to join the ABA, especially this section, which is basically the major civil rights, civil liberties body within the ABA, and an absolutely wonderful group of people, including so many who are on the Zoom and everyone here today. You can join it at ambar.org/CRSJ. So I just want to thank everyone for joining us today. We have 1 or 2 more minutes, if maybe Wendy, Margot, and Ria, if you have 1 sentence or 2 that you'd like to leave us with, and then we are done. Wendy, how about you?
I am one of so many people in this country who knowingly or unknowingly have benefited from her work. especially those 10 years that are less known to people, that when she was a litigator, and her efforts step by step, carefully, changed the law in this country. Hundreds and hundreds of laws had to be changed in the wake of her work, and we are all the better for it.
Thank you. Margot, 30 seconds or so.
You know, what I love about Justice Ginsburg as a feminist was that she simultaneously valued femininity. She valued the stuff that was traditionally female, and she valued the people and the choices made by people who didn't want to take that path. And I think that that is an amazing combination, to simultaneously say the things that most women do, those are awesome. And the things that some women do, those are awesome too. Because the core point is that the state doesn't get to tell us how to be who we are. I just think that's the thing. And I have to say, I grew up singing along with that Marlo Thomas record, the Free to Be You and Me record. I don't know how many people on this call did, but I did. Like it was sort of, in my 70s childhood, it was kind of playing constantly. So that was nice. That was a nice sort of reminiscence for me to think about that. And maybe that is in fact kind of where she was.
Ria?
Well, I didn't grow up listening to the album, but my son has a Free to Be t-shirt, so I feel the connection too. And I'll just say, people often ask me how it feels to walk in RBG's shoes, and my answer is that all of us walk in her shoes. We all live in the nation that she built through her advocacy and through her jurisprudence, and we at the ACLU are the lucky ones who can attempt to carry on that legacy, and we miss her every day.
Well, thank you ever so much to everyone, and thank you to all of the people who joined us today. And we look forward to seeing you at other programs of the American Bar Association.